Good day, everyone. Today we will tackle RA 10863's Title 11. Title 11 is all about the administrative and judicial procedures in customs administration. Enumerated are chapters 5 to 10 explaining the procedures on appeal, abandonment, the remedies, the judicial proceedings, and the disposition of the property in customs custody.
Good day everyone, I'm Nathaniel Mamolo II, and I'll be discussing the Chapter 5. Chapter 5 Appeal in Protest and Forfeiture Cases. Section 1126 Appeal to the Commissioner. The forfeiture cases, a person aggrieved by the District Collector's decisions may file a written notice of appeal with the District Collector within 15 days of receipt of the decision or 5 days in the case of perishable goods and furnish a copy all records of the proceeding to the Commissioner, who shall review and decide the appeal with 30 days of receipt of the record. An appeal submitted after the time limit set out below be dismissed. Next, Section 1127 Automatic Review in Forfeiture Cases. Any decisions of District Collector that is unfavorable to the government is automatically reviewed by the Commissioner within 5 days of the ruling being issued. All the cases records must be upgraded. The Commissioner must be decide on the automatic review within 30 days of receiving the records or within 10 days in the case of perishable items. When the Commissioner does not render a decision within the prescribed period, or when the Commissioner renders a decision adverse to the government involving goods with a FOB or FCA value of 10 million pesos, the records of the Commissioner decisions are automatically elevated within 5 days to review by the Secretary of Finance. The Commissioner decisions issued with 30 days after receipt, the records of the 10 days in the case perishable items shall be binding on the Bureau. Next, but not the least, Section 1128, Automatic Review by the Secretary of Finance in other cases. In circumstances where there is no protest or forfeiture, the Commissioner will automatically examine any District Collector judgment that is unfavorable to the government within 5 days of deciding on the automatic review, within 30 days of receiving the records, or within 10 days in the case of perishable goods. The records of the cases must be presented to the Commissioner. When the Commissioner does not render an adverse decision to the government, the records of the case under review are automatically elevated with the 5 days of the review by the Secretary of Finance. The Secretary of Finance decision whether or not rendered by the Commissioner is issued with 30 days of receipt.
Chapter 6 is all about abandonment. Technically, there are two types of abandonment, the express and the implied abandonment. Letter A illustrates express abandonment wherein the owner, importer, or consignee of the goods expressly signifies in writing or by submitting an affidavit of abandonment to the district collector with the intention to abandon the goods. It is called express abandonment because the owner of the goods expressly or duly express his or her intentions in terms of abandoning the goods. CAO 17 added that the affidavit of abandonment submitted by the owner shall be verified within 3 days from its filing and within 3 calendar days from verification of the affidavit of abandonment. The district collector concerned will issue the corresponding decree of abandonment for the goods expressly abandoned. After that, the goods shall be deemed property of the government. Next, letters B, C, D, and E illustrates implied abandonment in different situations. So, implied abandonment is the abandonment of goods without prior notice to the district collector. So, kabaliktaran siya ng express abandonment because dito sa implied abandonment, walang pasabi yung importer or owner of the goods na i-abandon na pala nila yung kanilang kargamento. So, letter B, wherein the owner, consignee, importer, or interested party of the goods, after due notice, fails to file the goods declaration within the prescribed period. So, That is the first step. Kapag walang goods declaration na dineclare after the due notice or the prescribed period, the goods shall be deemed impliedly abandoned. Letter C is kapag lodge na ng goods declaration yung owner, but they fails to pay the assessed duties and taxes and other charges within the prescribed period. So, hindi nila nabayaran yung kanilang mga dapat bayaran, isa na rin siyang step leading to the abandonment of goods. Letter D, kapag nakapag-lodge na sila, nakapagbayad na po sila ng mga duties and taxes, pero the owner, the consignee, or the importer of the goods fails to claim the goods within 30 calendar days from payment of the duties and taxes. Or letter E, when the owner, importer, consignee fails to claim the goods in customs bonded warehouses, the district collector concerned shall issue notice to claim the goods within 5 calendar days upon full payment. Goods unclaimed shall be deemed abandoned. So, all abandoned goods shall be subject to due notice requirement. For itong due notice requirement is to inform the owner of the goods na na-abandon na pala yung kanilang mga kargamento. Is to give them chance to reclaim their goods for a specific period of time. So, for accredited importers, the required notice shall be sent through registered email submitted to the account management office or its equivalent office. Para naman sa mga non-accredited importers, the due notice shall be served by registered mail or personal services. Lastly, for unknown consignee, the due notice shall be deemed complied with upon posting of the required notice in a public place at the concerned collection district or port for a period of 15 days and electronic or printed publication for a period of 15 days. So, now, let's see how the Bureau treats and dispose abandoned goods. Section 1130 explains that lahat ng mga na-abandon na goods shall be deemed the property of the government and shall be disposed through auctions or public sales or in accordance with the provisions of this act. Kasi iba-iba yung treatment sa mga perishable goods and non-perishable goods. So, if the Bureau has not yet disposed the goods, yung mga owners ng impliedly abandoned goods, pwede nilang ma-reclaim provided na lahat ng mga requirements ay na-complied na and dapat nabayaran na rin nila lahat ng mga dapat bayaran bago ma-release ang kanilang mga kargamento sa customs custody. And if the Bureau already sell the abandoned goods, the proceeds of the sale after deduction of any duties and taxes or any charges shall be turned over to the persons entitled to receive. Pero kapag hindi naman kayang mabigay or for example for unknown owners na hindi nila alam kung saan ibibigay yung mga proceeds, the sale or the money shall be held at the disposal of the Bureau, and after the lapse of the specified period, the balance shall be transferred to the forfeiture fund as provided in Section 1151 of this Act.
Hi, my name is Morris J. M. Mercader, and now I'm going to tackle about Section 1131. So, in this section, 1131, the Customs Commissioner have the authority to make a dispute or agreement towards the importer or any stakeholder that has fine or subcharges to the Bureau of Customs. Like for example, the importer has administrative case with the custom, and in order for them to reach a certain decision, the Customs Commissioner can use this authority under Section 1131 that they can settle this administrative case through payment or imposition of fine and surcharges.
Good day, sir. Good day, group mates. In this video, I'm going to discuss the Chapter 8 of the CMTA, which is the civil remedies for the collection of duties and taxes. In this chapter, there are three sections. And based on my own understanding, um, ang chapter 8 ay civil remedies. Kumbaga, ito na ang pamamaraan ng Bureau of Customs na patawan ang subject kasi dito is yung mga offending importer na hindi na or wala nang kakayahang magbayad ng duties and tax sa government. Dito na papasok ang civil remedies, which is based on my understanding there are three civil remedies. First is distraint of property. Second is constructive distraint of property, and third is levy on real property. The first civil remedies is the distraint of property. Yun na nga, when an offending importer failed to satisfy the Bureau may file a warrant of distraint or seizure on his property, including goods, effects, chattels, and other personal property, whatever character, including stocks and other securities, debts, credits, and bank accounts. The second civil remedy is the constructive distraint of property. Dito sa constructive distraint of property ay nire-require ng BOC ang offending importer na mag-sign ng contract na nag-state na obligated siya na mag-take care ng na-seize na property ng BOC galing sa kanya. At kung yung offending importer na yon ay nag-fail siya, hindi siya pumirma doon sa kontrata na hinihingi ng gobyerno or binigay ng gobyerno sa kanya na dapat siya ay pangalagaan niya yung mga na-seize na goods ng gobyerno, dito na papasok yung customs officer na nagdadala nung warrant of distraint ay maglilist siya ng mga na-seize na property na may kasamang dalawang witnesses at pupunta sila dun sa premises at magdadala ng copy na ito na nagpapatunay or nagsasabi na itong premises na to, goods na ito, kotse na ito ay deemed to be under constructive distraint na ng gobyerno. Ang huling remedies ay levy on real property. Papasok lang tong levy on real property kung ang offending importer na kahit na-seize na yung mga personal property niya, na-seize na yung bahay niya, goods niya, kotse niya, collectibles niya, furnitures niya, pero hindi pa rin yun sapat para makabayad siya ng kabuuhan niyang utang dun sa BOC, ay dito na yun papasok yung levy on real property. Pwede na i-distraint or i-seize ng gobyerno through BOC yung kanyang mga real property. Ito ang real property ay itong land at buildings. Levy on real property is yung right to possess. May sa BOC na yon or sa gobyerno na yon, gobyerno na ang owner ng kanyang building, land, pwede na yun gamitin ng gobyerno for public use. Pwede na kahit anong gawin doon ng gobyerno sa kanyang land ay may karapatan na ang gobyerno dahil na-seize na ang kanyang real property. Take note guys, yung mga na-discuss ko na civil remedies is yung distraint of personal property, constructive distraint of property, and levy on real property ay i-impose lang yun ng gobyerno kung ang utang ng isang offending importer ay more than 10,000 pesos. Kung yung utang niya ay bababa lang sa 10,000 pesos, hindi siya pwedeng ma-impose sa isang importer.
So I'll be discussing the next topic, Chapter 9, entitled Judicial Proceedings. So first, let's define what is judicial proceedings. When you say judicial proceedings, it is a legal proceedings in a court, a judicial contest to determine and enforce legal rights. Section 1135, supervision and control over criminal and civil proceedings. Sa section na ito, ang mga aksyon sibil at criminal na paglilitis on behalf of the government under the authority of this act o iba pang mga batas na pinapatupad ng Bureau ay dadalhin sa pangalan ng Government of the Philippines at dapat itong usigin at pangasiwa ng Bureau of Customs sa tulong ng Department of Justice. At nakasaad rin sa section na ito na ang pagpapasya ng pagkakaroon ng probable cause at ang kasunod na pagsasampa ng anumang criminal or civil case with the proper court against sa mga violators ay dapat na eksklusibo sa Department of Justice. Pero gayon pa man, nakasaad rin sa section na ito na walang civil o criminal action for the recovery of duties and the enforcement of any fine, penalty, or forfeiture under this act shall be filed in court nang walang pag-aproba ng commissioner. Halimbawa nito ay sa case ni Alvin Mercado. Sa case ni Alvin Mercado na pinamagatang Alvin Mercado, the petitioner versus people of the Philippines. Sa case na ito, si Alvin Mercado and his co-accused were charged in the RTC with the violation of Section 3602 in relation to Section 2503 of the Tariff and Customs Code of the Philippines, or the TCCP. They are accused for willfully and unlawfully made an entry upon items by means of false and fraudulent invoices. Pero bago pa ang madalang kaso na ito sa court, ay dumaan muna ito sa pag-aproba at pagsuri ng commissioner. At ang kaso na ito ay nagsimula taong 2000 at natapos March 18, 2005. Pero ang ending ng kaso na ito is hindi nila napatunayan na guilty si Alvin Mercado and his co-accused sa kasong isinasampa sa kanya. Next. Section 1136, review by the CTA. Sa Section 1136 na ito, unless otherwise provided in this act or by any other law, na ang partidong agrabyado sa pasya o sa desisyon ng commissioner ay maaaring umapila sa Court of Tax Appeal or the CTA sa paraan na sa loob ng panahong itinakda ng batas at mga regulasyon na ito. Maging ang desisyon ng Secretary of Finance kapag kinakailangan ay maaari ding iapila sa Court of Tax Appeal or the CTA. Maliban kung ang apila ay ginawa sa Court of Tax Appeal sa paraan at sa loob ng panahon na itinakda ng batas at mga regulasyon nito. Kaya ang pasya o desisyon ng Commissioner o ng Secretary of Finance ay dapat na final at sakto or conclusive. Ang halimbawa nito ay dun sa case ni Alvin Mercado at saka sa kanyang co-accused. Kung sa tingin nila is masyado silang na-agrabyado sa desisyon ng Commissioner or ng Secretary of Finance ay maaari nilang iapila, maaari silang mapila sa Court of Tax Appeal upang mapatunayan na hindi sila guilty sa mga kasong binibintang sa kanila. Next. Section 1137, exclusive jurisdiction of the Bureau. Sa section na ito, section na ito, 1137, jurisdiction over imported goods and goods for exportation ay dapat na eksklusibo sa Bureau o Secretary of Finance kapag ito ay under the review by the latter, which is subject to proceedings described in this title. Maliban sa CIA or the Central Intelligence Agency na walang court or korte na maaring maglabas ng anumang utos o desisyon hanggang sa maubos lahat ng remedies for the administrative para sa apila na ito. Halimbawa nito ay dun sa case ni Alvin Mercado versus people of the Philippines. The court did not give an order or decision until all the remedies for administrative have been exhausted. Pero in the end, hindi pa rin napatunayan na guilty si Alvin Mercado in his co-accused sa mga kasong ibinibintang sa kanila. Next. Section 1138. Fraud investigation and prosecution. Under this section, walang kasong kriminal para sa paglabag sa title na ito ay dapat na pasimulan ng walang pag-aaproba ng commissioner pursuant to the provision of this act. Ang Bureau ay dapat na magkaroon ng kapangyarihang mag-imbestiga at magsagawa ng mga kasong smuggling case na ginagawa sa loob ng nasasakupan nito. Sa kondisyon na sa kaso ng pagsisiyasat o maaaring itatag ng nakahuli ng customs officer. Halimbawa nito is ang mga smuggling luxury cars na halimbawa nito is ang mga smuggled luxury cars na na-confiscate ng Bureau of Customs or officers bago nila ito isagawa or gawin is kinakailangan nila ito ipaalam sa commissioner at kailangan ito aprubahan. Dahil hindi nila nagagawa basta-basta ang pag-investigate or prosecute ng mga case, mga smuggling case nang walang pag-aproba ng commissioner.
In Chapter 10, disposition of property in customs custody, abandoned goods, goods entered under warehousing entry but not withdrawn, or goods with unpaid duties and taxes within a period prescribed in Section 811 of the CMTA, and goods other than prohibited, restricted, and regulated goods proven to have been forfeited through administrative or judicial proceedings conducted under the provision of the CMTA, are among the goods in customs custody set for disposition. Section 1139, goods subject to disposition. Goods in customs custody that are in the process of being re-exported. Example, items that have been abandoned. So, goods that have been entered into a warehousing entry but not yet been removed, and those who have not paid their obligations and taxes before the deadline. In Section 1140, place of disposition of goods. On the district collector, orders at the port where the products are being sent. They may be sold or otherwise disposed of until the commissioner directs its transfer to another port. So, Section 1141, mode of disposition. After the approval from the Secretary of Finance, the goods subject to disposition may be donated to another government, agency, or declared for official use by the Bureau, or sold at a public auction within the 30 days after 10-day notice posted in a public place at the port where the goods are located and published electronically or in a general circulation newspapers. My example of Section 1141, mode of disposition. Disposition have three types: assignment, sale, and transfer. Disposition including an assignment and or a transfer can also be conducted for accounting and tax purposes to avoid any related taxes or liabilities. It can also refer to the sale of an asset used as collateral for a loan. Section 1142, disqualification of participate in auction sale. No customs officer or employee, their wives or relatives under the fourth degree of consanguinity or affinity may be directly or indirectly bid in any customs auction. My example here of the auction. Section 1143, disposition of proceeds. The excess of the partnership revenues received from the sale, exchange, or other disposition of all or substantially all of the partnership's property less any expenses incurred or paid by the partnership in connection with such transaction. Example, alternative disposition methods. Sell and use proceeds for other capital projects. It means sell property and use the proceeds to reduce the gross project cost of another FTA eligible capital transit project. Section 1144, disposition of perishable goods. Perishable goods as defined as under this act when certified as such by the Bureau may be sold at a public auction within 5 days after 3-day notice. So, my example of disposition of perishable goods. All of the following are usually considered as perishable goods for shipping purposes. Like for example, fresh food items such as produced and meat.
Hey everyone, I am Alik and I will be discussing Section 1146, or also known as Disposition of Prohibited Goods. Prohibited goods as provided in Section 118 shall be destroyed except Section or Paragraph D. Paragraph D defines as the manufactured as a whole of gold, silver, precious metals, or any made of alloy that does not indicate the fineness of quality shall be not destroyed and should thus be turned over to the BSP, or also known as Bangko Sentral ng Pilipinas. All goods suitable for shelter, foodstuffs, clothing materials, or medicines may be disposed in accordance of Section 1141 of this Act. Next is Section 1147, or also known as Disposition of Restricted Goods. Restricted goods as described in Section 119 of this Act shall be disposed as follows. Paragraph A. Dynamite, gunpowder, ammunitions, and other explosive firearms and weapons of war and parts thereof shall be turned over to the AFP. AFP means Armed Forces of the Philippines. Letter B, or known as Paragraph B. Relay wheels, gambling outfits, loaded dice, marked cards, machine apparatus, or mechanical devices used in gambling or the distribution of money, cigars, cigarettes, or other goods when such distribution is dependent on chance, including jackpot and pinball machines or similar contrivances and parts thereof, shall be turned over to the appropriate government body or agency. Paragraph C. Lottery and sweepstakes, tickets, and except advertisements thereof and lists of drawings therein shall be turned over to the appropriate government body or agency. Paragraph D. Marijuana, opium, poppies, coca leaves, heroin, or other narcotics or synthetic drugs which may hereafter be declared habit-forming by the President of the Philippines, or any compound, manufactured, salt, derivative, or preparation thereof should be turned over to the Dangerous Drugs Board. Paragraph E. Opium pipes and parts thereof of whatever material shall be turned over to the Dangerous Drugs Boards. And lastly, all other restricted goods which are highly dangerous to be kept or handled should be destroyed in a manner as the District Collector deems appropriate. Otherwise, the restricted goods shall be turned over to the proper government agency for appropriate handling. In Section 1147, Disposition of Restricted Goods, I made a table which all the restricted goods will be placed or disposed to or to be submitted in such a government agency, like dynamite, gunpowder, ammunition, explosive firearms, and weapons of war will be turned over to AFP. Relay, wheels, gambling outfits, and moreover shall be turned over to the appropriate government agency and others. Next is Section 1148, or also known as the Disposition of Regulated Goods. Regulated goods shall be disposed of in a manner to be determined by the appropriate regulatory agency. In the event that regulatory agency allows the disposition of the regulated goods, which commercial value incapable of legitimate use, This shall be disposed of in accordance with Section 1141 of this Act. Next is Section 1149, Disposition of Unsold Goods for Want of Bidders. Goods subject to sale at public auction by the Bureau shall be sold at price not less than landed cost of the goods adjusted for normal depreciation. Goods which remain unsold after 2 public biddings, either due to the lack of bidders or lack of acceptable bid, may be donated to another agency or declared for official use of Bureau. If the goods are not suitable either for official use or donations, this may be subject to re-export as government property or sold through a negotiable sale. In case of negotiated sale, the same shall be subject to the approval of representative of COA. For purposes of donating the goods, as above described, goods suitable for shelter or consisting of foodstuffs, clothing materials, or medicines may be donated to DSWD. Next is Section 1150, or also known as the disposition of smuggled goods. Smuggled goods, when forfeited, shall be disposed of as provided in Section 1148 of this Act. There are some notes that all proceeds from public auction sales after deduction of the charges as provided in Section 1143 of this Act and subject to the claim of the owner or importer of an impliedly abandoned goods as provided in Section 1130 of this Act shall be deposited in an account to be known as forfeiture fund. Forfeiture fund, or also known as Section 1151, all proceeds from public auction sales after deduction of the charges as provided in Section 1143 of this Act, and subject to the claim of the owner or importer of an impliedly abandoned goods as provided in Section 1130 of this Act, shall be deposited in an account to be known as forfeiture fund. The fund shall be in the name of and shall be managed by the Bureau, which is hereby authorized, subject to the usual government, accounting rules and regulation, to utilize it for the following purposes. Paragraph A. To outsource subject to the rules on government, procurement, establishment by the law, management of the inventory, safekeeping, maintenance, and sale of goods submerged in Section 1139 of this Act to private services providers, provided that the Bureau shall retain jurisdictional control and supervision over these goods as well as the operations of the service provider so contracted.
So that's all. Thank you.